Уважаемые коллеги, мы продолжаем. Не все к нам вернулись.
Dear colleagues, we continue our session. I hope more people will join us. They're still drinking coffee, and the topic of this discussion is development of the regulatory basis and development of new instruments, and this new instrument of endowments in the charity business. And now I would like to give the floor to Ilya Chukalin, who will be saying not only as an expert, but he works in the Ministry of Economic Development, so he will be outlining their position as well. Okay, so this is for you to change slides. Okay, well, I'm downloading a presentation, and while we're doing this, I would like to say, speaking about the state support of endowments, I'm a member of the Coordination Council of non-commercial organizations, and I've been involved in this work for a number of years. What I would like to start with, we have a very interesting topic of this session, because it is the problem of regulation of endowment activities in Russia. And there's certain specific points. So we keep using these terms, charity and endowments. And but in the law on charity of the Russian Federation, it is written specifically that it does not cover endowment activities. So logically speaking, we do understand that endowments can be used for charity, but currently by law, this is excluded from philanthropy. Speaking about state support, apart from the main document, which is the federal law I'm referring to, there are also acts, or a concept of enhancing charitable activities that was approved in 2009. And this concept outlines the state position in this area. So it is specified what conditions should be created for development of endowments, and also it includes specific measures, regulatory measures, for this mechanism to become more effective and to develop it in this country. So those measures that were included into that concept in 2009, they were implemented by two federal laws. And the first and significant measure that was declared by the concept, and that was it became effective on the 1st of January 2012. This is an introduction of tax deductions for donations to endowments. This is for individuals, not for legal entities, but for physical persons. So there's an amendment to tax code, and when a person donates a contribution into an endowment, then these people can get it deducted from their tax base. But there is a restriction, and for Russia it is a very big amount. Actually, the person can donate up to 25% of their annual income. So this is a lot for Russia. So 25, 1/4 of the total income. And as for other social deductions, you know probably that usually specific amounts are given. For example, 25,000. Dear ladies and gentlemen, in 5 minutes in the amphitheater on the big stairs, there will be a presentation of the International Anti-Corruption Academy. We are inviting you to this presentation. Yeah, global announcement.
End of the forum, 5 minutes in the amphitheater, the big staircase. The presentation of the International Anti-Corruption Academy will start. All of you are welcome at the presentation.
So if in the laws, for example, when you buy an apartment and you can get 2 million rubles deducted from your tax base, but in this case, no specific amounts are given, only the percentage, which is a very good incentive. In addition to this, other measures included into that concept were reflected in the acts related to endowments. So right now, it is specified what happens if an endowment fund stops its activity. What happens to this money? So this is regulated by law now. Then there is another thing which didn't exist before, and the charity committee of the public chamber played a great role in this. And now it is possible to add stock and real estate property or movable assets to endowments. Before that, it was only funds that could be added, and now there is an opportunity to include stock and immovable assets. And we see that the purposes are extended now, purposes for which endowments can be created, because we do have limitations of the areas for which endowments can be created, and we are now members of the legal forum. It is important that it can be created for legal support, for example, pro bono legal activities, and for environment protection. This is also a very significant achievement. And the concept specifies that these are just first steps, and this list can be extended if it is justifiable and necessary. What is the main thing and logic of the state support? There are certain tax mechanisms, because the form in itself, the form of support in itself, is reasonable only if there are certain tax benefits. For example, that income tax deduction for people, for individuals, and here the regulator.
Now, the law regulates this issue in terms of how this endowment can be formed, and if real estate, immovable property, or other assets are contributed to it, they are not taxable. Although the VAT is not refundable, so this has been settled. And the main thing is the profits tax, which is what companies are mostly interested in, and the endowment foundations as well. Everything that an endowment foundation earns or receives is not taxable. in terms of profits tax. The income generated by the endowment, including the yield, is not taxable, and there are two options when there's a charitable organization creating an endowment foundation, and there are specialized organizations that create endowments to help other charitable organizations. So in this latter case, like Skolkovo, these assets are not taxable either. So this has been fully settled as well. Now, what remains unsettled, though declared in some policy documents by the government, it's the issue with legal entities. If we have tax deductions for natural persons or individuals, there's no similar tax deduction for companies. So companies may give donations to an endowment only from their net profits, but it's only shareholders that can decide that funds from profits be given to a charity. Now the principal concept stated the possibility of adopting a measure, and the Civic Chamber has supported it, of making that tax deductible as well, but so far this has not been resolved. And in part, this has been implemented, and I could give you some very interesting examples. For example, the tax code allows to make donations to innovation foundations accounted for as expenditure. So if you take the law on research activities, in principle, an endowment fund in the sphere of research will fall under the definition of an endowment foundation, because it's set up for financial support of research. So with regard to donations to that foundation, this regulation is applicable. So if a commercial organization donates to a research foundation, it may get this tax deduction up to 1.5% of the company's entire revenue from sales revenue. But the problem is it was not invented for this purpose, but the way it is worded now in the law, this is admissible. So based on this logic, the government could continue to expand the benefit to other areas, and this is under discussion now, and we hope that it will be implemented. So this encourages the development of endowments, and because Natalia mentioned this 2. This form of endowment is very significant for the state because it helps assure the stability of a number of models. It's widely applicable in areas where there's nothing like that so far, like culture or science. And as regards what else could be done, the mechanisms of various matching grants are also can also be made functional in this area too. And this is how the law on endowments is going to be perfected. The government has adopted a program also including the examination of adding government money to endowments. This is practiced in the United States and in the UK. For example, the National Welfare Fund could also be used for the setting up of endowments, because this is not any expenditure, this is not spending, this is just capitalization of budget money, also helping finance long-term projects, not only in science and research, but also in other areas. If it's not the full budgeting of an endowment, but partial challenge grants to expand an endowment and to encourage the development of that, and it could be a serious measure for state-financed institutions, and it could also be a measure of supporting socially oriented nonprofits. In any event, the government has said it is ready to consider various proposals on how to improve this mechanism. It is still in the development phase, but there's a group of experts working actively on this, so I urge you to join in and make your proposals. I hope that by the end of the year we'll have a bill ready. We'll get it discussed at the Civic Chamber first, and then submit it to the Cabinet of Ministers, and we'll continue to discuss other legal issues. Thank you. Other questions? I'm Vladislav Bulatov. The fact is, we have already argued with Larissa. There's Article 39 in the law. Putin last year signed a decree that up to 10% the tax code, and last year Putin signed a decree allowing up to 10% of taxable profits to be tax deductible. And then there's another issue when funds that are donated are also taxed at 35% for recipients, and if there's a piano granted to us music school, the school has to pay that tax. That's the real practice. That's what I was going to ask you about, but I would like to use the occasion to thank you as a representative of the Ministry of Telecommunications. You have a spectrum of musical nonprofits, including Radio Orpheus. As regards the taxation of organizations, of recipient organizations, I was a developer of the bill we sent last year to the Ministry of Finance, which envisaged classifying endowment donations as expenditure up to 10% of taxable profits. But the Ministry of Finance did not support it. We said we tried to suggest this 10% limit. The bill was discussed, but finally we could not overcome the Ministry of Finance's resistance. We decided to take a different path, which will take us longer to cover, but we are not abandoning this, and we will work to get organizations to be allowed to reduce their taxable base by those, to get those tax deductions. But at present, indeed, there's no way. The tax code only allows donation from net profits. Now, as regards those schools, Article 251 says of the tax code says that any donation is not taxable and is not included in the profits tax base. So if a school receives a donation and it's intended for its principal activity and not any commercial activity, then they do not have to pay anything. And the same is true of endowments, but for endowments, if it were a simple donation, you could resort to paragraph 1 and 2 of Article 251, but there's even a special provision saying that whatever goes into an endowment is not taxable, not VAT taxable, nor profits taxable, nothing. The thing is, this is what I know from Denis Matsuyev. Well, this is the law. It's not information. It's the law. You open the tax code and look it up there. Chapter 25 of the tax code describes everything in detail. So let's get back to the subject matter of our roundtable: endowments, legislation, practice, Russian and international experiences. Just one remark. I have spoken to Minister of Finance Siluanov, who supported this idea. But I have talked to Minister Siluanov as well. He is not supporting this this method of introducing this tax deduction. He's offering a very lengthy and complicated road, but we will take it. Thank you very much. Are there more questions? Thank you. Again, let's continue. What I was going to discuss has to do with the activities of charitable foundations in the endowment sector and the practices that are current in Russia. There's some interference. No, charitable foundations in Russia are actively financing non-profit organizations. This is a long-standing practice, financing by grant money and any redistribution of assets in non-profits is helpful to form the pools of non-profit organizations. But any financing of ongoing activities also generates expectations on the part of the non-profits that this is going to be forever. But of course, there are no sources of financing for an endless period of time. So any endowment foundations, any charitable foundation is surrounded by organizations that are competing for new donations as well as old organizations that have a history of relations with the foundation, and any non-profit organizations that are financed in this way are not encouraged to improve their capital base and create other sources of financing. So as soon as endowment legislation emerged, numerous charitable organizations were interested in it as a tool of capitalizing their programs. The issue of the future of every such foundation is a matter of principle, but the developers of the law and those who amended it later failed to resolve one serious problem, which prevents today's endowment funds from using the endowment tool in order to create their own internal capital and from issuing grants to other endowments. And this, of course, impoverishes the arsenal of endowment foundations. Imagine you have this list of 10 areas where you can form endowments. It's in fact the same as the list of charitable activities that our law on charity defines. Of course, charity is defined more broadly, but these 10 are, of course, among those described in the law on charity. So it seems to be logical, it would seem logical that if a foundation issues grants to non-profits under the same chapters as the law lists, but the money is not spent immediately, but is put into their capitals. Well, this looks civilized. And considering that endowment foundations as a new tool and new institution has been defined very well in terms of regulation, and there are no loopholes for abuse, because the law was based on Russian experiences, knowing how difficult it may be to catch on some fraudsters. This mechanism could be used for everybody's interests, and foundations would not only become stable and well-funded and capable of planning for decades ahead, but also enable them to support the traditional grant recipients.
In other words, if a charity foundation has a standing partner, an NGO, which is offered some funds to exercise their projects, say in education, then it would be quite logical if a foundation instead of allocating funds into installments, they would allocate it into an endowment, and it will help to increase the capitalization. That will make the foundation more stable, and it will address the problem of many Russian NGOs. Relating with the fact that many donors that support NGOs prefer to donate into projects. They are reluctant to finance their operations, and that's a systemic problem related to NGOs in Russia, because they have to keep on thinking where to get money to pay for office, for utilities, and that's a restraining factor. So the establishment of endowments, even through the contribution of the charity and organizations, will help to address that particular issue. So, speaking of some further logical steps to make if charity foundations are allowed to invest into NGOs, endowments. Here are the bullets that you can see here, and most of them relate to future sustainability of NGOs. And if it is done, we would shape not only financially safe organizations, but that would also allow NGOs to think of future strategies, and that would enable foundations to make their strategies of contributions. It's easy to find money to finance a project tomorrow, and it's hard to raise funds for long-standing commitments. And if charity foundations are not allowed to establish their own endowments now, we would really impoverish, we will reduce a list of potential donors, long-term commitments. And it was already pointed out today that fundraising is a fundamental problem for many organizations, and if it is addressed, we would increase the base of fundraising, because charity foundations are growing, and companies, we have corporate foundations. So if that opportunity is granted, we would make that process even more, even if better quality. So in conclusion of this part of the discussion, I would like to once again place an emphasis on the fact that current endowment legislation is quite logical, it's sophisticated and well structured. And the issue that I mentioned relates to the fact that in the charity activities legislation that was passed many years ago, there is no provision that would read about the contributions to endowments, because at that time there was no idea of that. So now we need to provide support to those organizations, and for that end we need to pass proper amendments. So my colleague Olga Vaitovich will tell you more on our expectations from the law community. Good afternoon, ladies and gentlemen, and participants. Frankly speaking, it's not easy to be the last speaker, since much of what I was going to say have already been covered, and that is why I'll try to summarize all those points that were made earlier, and articulate some proposals that you can discuss later on. To begin with, I would like to say that, speaking of social responsibility of businesses, we primarily mean philanthropy and charity activities. And it's not accidental that this roundtable dedicated to philanthropy was supported by the Minister of Justice here. just to underline once again the importance of this area for business community, and I would like to turn your attention to the fact that today we actually have two tools, two instruments for charity and philanthropy. Those are the charitable foundations, and their activities are regulated by the respective legislation. And the other, it's the law on endowments, and that is in the focus of today's discussions. You may be aware of the fact that the State Duma is discussing now a new law, a new draft law on philanthropy. But speaking of some historical definition of the term, then there is very little difference between philanthropy and charity. It's not. I'm not certain if some individual law is needed here, but that, again, it's up to legislators. And the drafters of the law could really have found all the answers to the questions in the endowments law. But anyway, it's not going to be a new category of charity. It will be just some addition to that. And speaking of historical roots of charity and philanthropy, today we're listening the presentations of our year's guests. It came to me that if you try to draw some parallels with the year's story, we can say that in Russia we had some similar activities about 100 years ago. And speaking of Mr. Cooper's time, we can recall charity activities of Sava Mamontov, who lived in the same years. Sava Mamontov was a major businessman and entrepreneur, and he invested great funds and great contributions to art, culture, and unfortunately, at that time, he was not that pragmatic, and the idea of endowments didn't come to him. And in Russia, we have always been guided by contributions and the idea of their direct use. If you get some funds, you know what they are dedicated for. And that's our mental set here. So when we try to understand why over the period of 7 years of the Endowments Act action or effect, we didn't see much progress here. I can say that unless a non-profit sector is well developed and sophisticated, we would not be able to really bring that idea back home to the minds of the people. So, despite the fact that the law is 7 years old already, and we should not be surprised at that, but there are some lawyers and bankers who tell us that they hear of the law for the first time when we talk to them about that. And speaking of the legislation, we should also remember that over the period of 7 years, the law was amended 4 times. And those amendments made the law better, both the technologies and the procedures. And the previous speakers have already made all the points about those changes and amendments. And in summary, I can say that originally the law meant only cash donations. Later on, it was amended to accommodate real property and securities as donations or contributions. And for a foundation to use certain types of property, they need to have already some funds to manage that. And all those amendments accommodated for that. And we had a broader list of purposes for which you can contribute. And in the first years of the law's application, there were a lot of interpretations of the law by lawyers. I can recall a situation when we were talking if a same endowment couldn't be passed to two managing companies, and originally it was the amount of 3 million. And at first we were afraid to transfer that amount to a managing company. I hope that those concerns do not exist any longer. But before we split that 3 million endowment, and probably it is not quite appropriate to say, but the Skolkovo's endowment, they kind of advertised that interpretation of the law, and I'm pleased to see an amendment later on that read very clearly that one endowment can be transferred to a single managing company. And that's about our situation some years ago with all those broad interpretations and visions. Speaking of other major changes, I don't think that I should speak of them for too long, because those who keep track of the legislation and its amendments are really aware of them. But we should pay some attention to proposals that can be supported, so that the endowment legislation can be further developed and sophisticated. And that's about tax benefits. It's the hot topic for everyone, and to be engaged in charity or not to be engaged, that's the decision of each individual and each legal entity. And perhaps it's just my private opinion, but people may disregard whether tax benefits are there or not. But if there are tax benefits, certainly we can see that as some incentives for individuals, for SMEs. And probably the story of the United States can serve us some example of how we can take advantage of that. And tax benefits have always been favored by us, specifically when it applies to corporate sector. And I think we should keep on trying to discuss further with Ministry of Finance and other agencies who are in charge of those amendments. And there was another very interesting point in the presentation of our US counterpart, and that's about the religious organizations. I cannot find the same provision in the Russian legislation that would clearly support the religious activities. And I think that for religious organizations themselves, the idea of endowments could be quite attractive. But again, it's up to them to decide and see if that instrument can be useful for them. Further on, I would like to say that as of to date, those foundations that have been in operation for 7 years now are very close to the phase when they can really see how they can use some tools and technologies to replenish endowments and raise funds. Today we have more questions how to use advanced technologies, and the law on endowments makes it clear that if there is a contribution is regulated by the endowment legislation, then there should be specific details of the payment, And really the advanced technologies which we are using now, cannot give us that opportunity in terms of technical aspects and in terms of legal aspects. So those ATMs and other cash machines are mostly designed for payments, for consumer payments, and should you make plans to raise funds using ATMs or cash machines, you should really be aware of the fact that there could be a challenge of tax benefit for individuals that we have now. And I think that legislators could further elaborate on that and clarify and fix that problem. And if we want to lay groundwork for the future, so that the youth would later be willing to make contributions and donations, then those concerns are to be addressed. I think I confine my remarks to just those points, because I would like to leave some time for discussions and Q&A. And as you might have noticed, I totally skipped my presentation. Mostly it's information about endowments, but I think you would forgive me for that, because what is most valuable for us is your feedback. So, dear colleagues, your questions are welcome. You're welcome. Please speak into the microphone. I'm Ekaterina Sorokanan. I'm CEO from the Hermitage Endowment. I have a number of questions. First of all, on the one hand, tax benefits is something that is very important to attract donors and raise funds. But there is another incentive, such as the letters of gratitude and other things. So when those letters of gratitude are posted on the website, sometimes it's viewed as advertising. In terms of endowments, I wonder if same letters of credit can also be viewed as some violation of the law. I don't think it will be the case, because even since the early days of the law's application, there was a provision that it doesn't suggest that should be the services in return. And when we asked in what way we can thank the donors, it was recommended that it could be some list of donors, and could be a website, and it's really important for them so that their names are mentioned, and I don't think it will be viewed as advertisement. And if there is if it is a company with a logo, it doesn't matter. Another question: foundations cannot make contributions to endowments, and what about autonomous NGOs? You mean autonomous non-profit organization? Are they allowed to contribute, to make donations to endowments? It's important to see that they are non-profit organizations. So if there is an internal decision taken to donate, then I cannot see any conflict with the law. But we should be aware of some tax consequences and implications. That's my immediate response. Thank you very much, because we used to discuss that with the Hermitage lawyers, and there was an opinion that an autonomous non-profit organization was not allowed to donate to endowment. Well, we should really be aware of all the funding sources of that organization, and probably the lawyers were guided by some other reasons, not of the legal nature. So we need to understand those reasons. And thank you for a reminder. And since I assumed the role of a person who would summarize our discussions, and I was talking about two tools for endowments. And I can say now that it's really important to merge the two sources and allow charitable foundations to make full use of the endowment.
And now the third question. In June, we are planning to organize an event where we would like to inspire participants of this event to donate online. And we don't see any chance how they can do it. They can do it only with their credit cards. So we are thinking what sort of agreement we should have for that. And we are trying to negotiate it with the bank. And we expect that the bank will have a commission. So we will sign an agreement with this bank, and there will be a clause on banking commission. So it will be a percentage of all those donations. And our donation agreement, and here we have a question. The whole amount first will hit a specialized account, and then from this special account, this money will go to the trust company or managing company. But at the same time, we need to pay the commission as well. So in our agreement, it will be specified that this is not payments for services, no, but these will be donations. So this is fine. We have already discussed it with the bank. But my question is, what do you think? This commission percentage, what do you think? So should it be from our administrative costs account? Or we can pay it directly from that special account where donations come. This is very, specific, and let's discuss it face to face later after this session. Okay, I'll make my question shorter then. But in principle, we can discuss this. Yeah, okay, I do understand what you are speaking about. And the law. In the law, it says that up to 5% of donations can be used for administrative purposes. So that commission you have to pay to the bank, it will be included into your administrative costs. So this is a way out. So from that special account, yeah, you can. So up to 5%, yeah, can be spent for your administrative purposes. Can I have a microphone? I have another question. My name is Ludmila Pantileva. I'm from the Assets Managing Department of Gazprom Bank. I am worried about this following. So, endowment funds cannot get donations through terminals. The terminals we have all over the city. So, I'm shocked by this because lots of banks now introduce internet acquiring through website, and this is payments through cards, credit cards, and at various events, yeah, people also would like to do it through those terminals. Yeah, and we have several agreements already, and we place this service, this internet acquiring service, at websites of various organizations. Could you comment on this? Yeah, we have considered cases when donations come through, or paid through these terminals. If there is an internet resource, yeah, it is possible. Yeah, you can pay from your credit card. Yeah, because at this moment, it is clear from what card it is paid. There's the credit card number and so on. But when we speak about those stationary terminals that are placed not inside the bank, but everywhere in the city, we need to work with software. That software should fix, should register who is paying, and 50% of the problems will be eliminated. And I just said that there is a risk. A risk, it can be questioned whether this payment is paid appropriately, because by law terminals are installed to ensure payments for services and goods. And so here there is a contradiction. Dear colleagues, I would like to clarify. Those terminals, it's like Kiwi systems, anonymous payments, where you pay cash. And it is impossible to identify who is paying. And this is an important problem. Second topic is that whether this payment system can identify the payer. If it is possible to archive the data, if it is possible to identify who is paying, then the situation is totally different. So it all depends on what we call by these terminals. Yeah? So the public chamber, so we have a big pool of experts, and we are working towards a system so that people could allow payments anonymously. Yeah, but if the maximum is 5,000 rubles, yeah, for example, or 15,000, yeah, but it's not that much still, and all those concerns about terrorism, that terrorism can be financed like that, but how many people should donate 5,000 each, to get an appropriate amount? I have another question. So this is not about those payment terminals. Didn't you have an idea to have a hotline on endowments? Because there are so many questions, and everybody is looking for their ways out, and they are looking for advisory services, and all this is done in different places by different people. So we don't see that expertise in this area is accumulated. And maybe some grants can be provided for this. So I'm just interested whether there's interest in this, in accumulation of this knowledge and expertise. We do have a forum for endowments. It is called Endowment Club. And this is created for those companies who have these questions, and I believe that the number of funds and the number of requests from them, so I don't think it is reasonable right now to create this hotline. There are not so many questions or requests coming from them. I believe that this club is sufficient. And of course, if some of the donors would like to finance establishment of this service, permanent service, legal service, then yeah, we are ready to consolidate expertise in this area. Okay, dear colleagues, are there any other questions? If not, let me conclude this discussion. I believe we have managed to give you a good picture of what is going on in the area of endowments. I believe that this is one of the most dynamically developing area of the non-commercial sector, and I think that a higher quality regulatory base in this area is possible, and it will bring tangible, visible results, because even during this short period when we have these normative acts, already we see certain results. And before, none of universities or museums or donors were incentivized for establishment of endowments. And in the United States, for example, as we heard today in that interesting presentation, this has been existed for hundreds of years already. And I believe we are accumulating interesting experience, and we do have what to discuss and what to analyze. And I believe that our colleagues who work in this interesting area of regulation, of legal support of endowments, they will be our partners, because, of course, a lot will depend on the regulatory structure in this area, and we are open to any form of dialogue. Thank you very much for your attention.